Hello, everyone, and welcome to Fairfield County SCORE's live webinar, Copyright Basics for Artists, Photographers, and Other Creative Types. This is part of our series for creative people in business, and we're really pleased with your very enthusiastic response. On August 10th, our webinar will cover trademarks. If you've missed any of these webinars in the series, they will be available on our website, fairfieldcounty.score.org. I'm Ruth Kelly, the webinar coordinator and a business mentor here at SCORE Fairfield County. I'll be your host today, and our presenter is Cliff Ennico, but more on Cliff in just a minute. First, a little brief information about SCORE. We're a national not-for-profit organization affiliated with the Small Business Administration. Here in Fairfield County, our chapter has over 130 volunteers with a wide range of experience. We offer three primary services to small business owners. First is free one-on-one counseling. That could be face-to-face, video, telephone, email, video, and Zoom, which can be accessed by Request Mentor link on your website or via the link on the screen in front of you. The second area is educational workshops and webinars, and this really is one of them, a webinar. We have over 150 throughout the year. And finally, an extensive resource on our website, including a network of subject experts at your disposal. Look at our website, fairfieldcounty.score.org, to see the wide range of topics. Now, some useful information about today's event. We've set aside time for questions and answers at the end of the presentation. If you have a question, please use the question and answer Q&A window at the bottom of your screen at any time during the presentation. Our webinar will end sharply at 1. This session is being recorded, and the link to the recording will be available at fairfieldcounty.score.org. Now, it's my pleasure to introduce Cliff Ennico. Those of you who already follow SCORE webinars know Cliff well. He's one of our most popular speakers. Cliff is a local attorney, and today he'll talk with us about how copyrights relate to your business. Cliff's a nationally known authority on legal issues in small business. He's the former host of Money Hunt. His weekly business advice columns appear in many newspapers and websites throughout the country. North America, it says in the notes here. You'll see him in Entrepreneur magazine, and he has over 100 videos on YouTube. Welcome back to SCORE, Cliff. The floor is yours.
Hey, thanks, Ruth, and thank you for that wonderful introduction. Well, for those of you who are not familiar with me, one of the things in her introduction should have just jumped out and hit you between the eyes, which is I am an attorney. Okay, I try not to drop the L word, as much as possible. But if you ever doubted that I am an attorney, this slide will convince you that I am. We always tell you a little bit about what we're not going to do before we tell you what we are going to do, and the most important one really is the second one. There's a lot. We're going to be talking about some legal stuff today, and in some detail too. But there's a very big difference between giving out legal information and giving out legal advice. Here's what the law is all about: is legal information. Here's what you should do, Ruth, and this is why you, Elliot, should do something different. That's one-on-one advice, and I really can't do that on a program of this nature. I really don't know any of you well enough to be able to give you the kind of one-on-one advice that if you were paying for these services you would get. So I mean, if you do hear something on this program and it sounds like a good idea and you do it and it doesn't work out and you end up losing your business, filing bankruptcy, your kids don't talk to you, your spouse divorces you, your dog pees on your leg, and you end up living in a diaper box under the Brooklyn Bridge, you can't sue anybody. That's what this disclaimer is all about. As Ruth mentioned, this is the beginning. This is the third of a 4-part series on business issues for creative artists and creative businesses. I work with a lot of artists, photographers, authors. I myself am an author of 16 books. I've had to negotiate every one of my own publishing contracts, which is how I got into this business in this sense. But I want to begin by repeating something that I did on the first program 2 weeks ago. And those of you who have listened to all 3 of the programs so far, I'm going to apologize. I'm going to repeat something that I did 2 weeks ago, but it's a very good way to get started. I'm a visual thinker. I like to think in pictures and diagrams and checklists and stuff like that. So I think it's useful to have a visualization of what a copyright is. So I'm going to ask you, please indulge me for a minute. I want you all to close your eyes for a moment. Don't worry, we won't leave you here. Close your eyes, and I want you to visualize a table in a room, and on the table is the Mona Lisa by Leonardo da Vinci, probably the world's most famous painting, if I had to pick one. We all know what the Mona Lisa looks like, right? Picture it, it's sitting there on the table. And now I want you, just about 3 feet above the painting, I want you to picture a hologram, a three-dimensional picture, which looks exactly like the Mona Lisa, down to the last brushstroke. But it's not tangible. You can stick your hand through it. It has no physical substance. You can look at it. Maybe you can move it around, but you can't touch it. You can't smell it. You can't, taste it. You can't do anything else but look at it. Now, as the last part of the exercise, I want you to leave the hologram hovering in the air and remove the painting and the table from your view, and just leave the hologram in the air. Okay, now that's the last part of the exercise. You can open your eyes now and rejoin the program. And if you have fallen asleep, okay, wake up. Okay, I always worry in my live programs. There's always somebody who has trouble waking up from that exercise. I get very nervous about that. But here's the thing. It's a perfect. I love that visualization, because it's a nice metaphor for what a copyright is. When you create an artistic work, whether it's a painting, a photograph, a literary work, any kind of design, if you're an architect, a particular design for a building, those have been copyrightable now for about 30 years. You don't just create the thing itself, the physical object. You also create at the same moment, a copyright, which is the hologram. The hologram is the copyright, and the copyright does not go with the physical object. The reason why I told you to take the Mona Lisa away and leave the hologram in the air is to illustrate a very important point. When you create any kind of creative work, you create 2 things. You create the physical thing itself and the copyright. And the copyright does not go with the physical object. If you sell the physical object, if you destroy the physical object, the copyright remains. And the copyright is separate from the work of art, and it's the way in which artists and other creative types get rich. Okay, creative types rarely, if ever, get rich by selling the physical objects. Where they get rich is through their copyrights. That was a basic lesson. We covered it 2 weeks ago, but I think it's very important to reinforce that, because it's where everything begins, is with understanding what a copyright is. A copyright has nothing to do with ownership. People have this concept, if I own the copyright on it, I own it. That's not strictly speaking accurate, and it's not legal accurate. What it really is a legal monopoly, is what it is. Now, we all know we live in a capitalist society, and in a capitalist economy, monopolies are not a good idea. When a company gets so powerful that it has monopoly power, it can basically charge people whatever it wants, and consumers don't get a good deal. That's why we have a set of laws that are called the Antitrust Laws, which are designed to prevent certain companies from getting to that level of power. And break them up after a while when they get too big. There are some people who feel right now that companies like Amazon and Facebook have reached that point where they really should be broken up. They're becoming a little too powerful. We're not going to get into that. But a copyright is a legal monopoly. The government gives it to you, and the antitrust people will never take it away from you. It's the legal right to exclude others from profiting from a creative work for a period of time. And the period of time varies depending on the type of work. We'll talk about that later. It's one of the few things in law that actually is named the right way. The name means what it says. It's the right to make copies. That's what a copyright is, and publish the work and make reproductions. And it's not just one thing. It's a set of rights that change over time. Okay. So what does copyright protect? Well, a copyright protects original works of art: literary, dramatic, musical, artistic, poetry, novels, movies, songs, computer software, a very important part of the copyright laws. Computer code being in the form of text is copyrightable. Not trademarkable, which confuses a lot of people. Computers, if you're a computer code designer, and if you know how to code software, that's the copyright world you're in, not the trademark world. Architecture, since 1991, you are allowed in the U.S. to copyright works of art. So you can certainly design a museum, but you can't design a museum that looks exactly like the Bilbao, Spain museum that Frank Gehry designed. That design is copyrighted. I'm sure in the European Union as well as the US. What the copyright does not protect is ideas. It does not protect intangible ideas. It only protects the expression of those ideas. So for example, if I wanted to write a series of books about a young boy who discovers he has wizarding powers, and he goes to this university where there are all other wizards who are learning how to do wizarding type stuff, as long as I don't make the characters look too much like the Harry Potter characters, I can do that. And J.K. Rowling can't do a bloody thing about that. She's the author of the Harry Potter books. She can't sue me for infringement as long as I'm careful. In fact, I will tell you that there is an author who has done that. His name is Lev Grossman. He has written a series of books called the Magician series. They just made a movie out of the first book, I think, a couple of years ago. And it's Harry Potter for grown-ups. I like to call it Harry Potter with sex, is basically what his books are. This boy discovers that he's a wizard, but he doesn't discover it until he's in high school, when all the hormones are ranging, and he goes to this university for wizards. And let's just say that it's a more adult version of the Harry Potter books. But so far, no one has ever sued him for copyright infringement, because his characters and his scenes are very different and unique from what J.K. Rowling did in the Harry Potter books. So here are some of the things you maybe can copyright. Your website. People ask me this all the time. If I write original text for my website, can I copyright it? The answer is yes. If it's original content that you created, you didn't steal it from somebody else, you can definitely copyright it. Your domain name, no. Your website URL, cliffennico.com, you protect that by registering it with a registrar, and then maybe if you have a distinctive name, getting a federal trademark. We're going to talk about trademarks next Tuesday. So please hold off the trademark questions, because a lot of them will be answered. Most all of them will be answered next week. Your recipe for baked beans, no, if it's just a mere listing of ingredients, but yes, if it's accompanied by substantial literary expression in the form of an explanation or directions. That's why if you ever read a cookbook, it's never just the recipes. They always have this little paragraph about how the author was in Tuscany and they went to this little family restaurant and they found this wonderful recipe for ossobuco, and that's why they do that, because by doing that, they can protect the copyright on that recipe. And of course, a collection of recipes can be copyrighted. So The Joy of Cooking, for example, is a copyrighted work, even though it's mostly just recipes. Your company name, no, that's trademark world. Anything that you use to identify yourself in commerce, any kind of logo or design is a trademark thing, not a copyright thing. A directory or database. Now, this gets complicated. You're going to have to talk to a real lawyer for this one. The directory or database itself can be copyrighted, but the individual items of data may or may not be copyrightable, depending on whether or not they're original works of art. That gets complicated. That's something you're going to have to pay a lawyer some money to answer. What about outside the United States? Well, in the copyright world, we're very, very lucky because back in the 1800s, the world got together and set up something called the Bern Convention. Bern as in Bern, Switzerland, the capital of Switzerland. Right now, virtually every country in the world, with only 2 or 3 exceptions, North Korea, Cuba, people we don't like, is a signatory to this treaty. And what it basically says is that if a work is copyrighted in a member country, a country that has signed on to the Berne Convention, and all other signatories must honor that copyright. So if I create a work in the US and I discover that someone in India has knocked me off and is selling it on Amazon for 2 pennies or something a download, I can definitely get an attorney in India and shut that person down, because India is a signatory to the Berne Convention. The last time I looked, China was a signatory, but but North Korea is definitely not. So Kim Jong-un's memoirs, I don't know about that. He may have some issues there. When does copyright attach? Believe it or not, you do not have to register the copyright with the Copyright Office to claim a copyright. The copyright attaches at the moment of creation. The minute you finish the work, if it's ever finished, of course, most of you take like 30 years to do a painting. I know you're just like my clients. I'm not knocking anybody. All my clients are like this. It's never finished. Anybody who designs websites knows the website is never finished. There's no such thing as a completed website. So the copyright attaches when you create the work, but it's a good idea to register the copyright with the Copyright Office, because what you need to do, if someone else says, hey, you ripped me off, you stole my work of art, you have to prove the date of publication. And a copyright registration is the absolute perfect way of proving the date of publication. So if I have a registered copyright with the Copyright Office for my new novel, and someone else says that I ripped them off, I can go to court and hand them a copy of that registration. And now it's the other side's burden to prove that they had created this work before that date, before I registered my copyright. That's what the copyright date did. The copyright registration does. It establishes the date of publication. How do you protect a copyright? Well, there's 2 things you need to do. You need to put the statutory copyright notice, which, by the way, if you miss it here, look at the bottom of each one of these slides. You see those little thing that says the copyright symbol, 2015 to 2021, Clifford R. Ennico, all rights reserved. That is the statutory copyright notice. Is what that is. It looks exactly, it's the copyright symbol or the word copyright written out, the name of the year, the name of the author, and then I always add the words all rights reserved. What that means in layman's English is, any rights that I don't specifically give to someone else. Remember I said a copyright is a bundle of rights. Any rights that I don't give to other people, I retain and I own those. So if you're looking for electronic rights to something and I have not given my electronic rights to somebody else, I'm the one you deal with there. Whenever you're looking to use someone else's copyrighted work, you want to know who owns the copyright and specifically who owns that specific bundle of rights. Years ago, a lot of people did not like to register their copyrights with the Copyright Office and sometimes it's a bad idea. There are what are called copyright trolls out there. These are people who troll the copyright register. What they're looking for is ideas that they can steal. Remember, you can't copyright an idea. So if I troll the copyright records and I see, that you've copyrighted a book about this crazy kid who thinks he's a wizard and he gets into all kinds of trouble, and I say, you know what, I could tweak that a little bit. I could take that, I'll make him a girl. I'll change some things around, and I can make this distinctive enough that I could probably work around that copyright. You've just let me do that by publishing your copyright. So what a lot of people, especially authors, used to do in the old days is they used to do poor man's copyright in the old days, but we took the sexist language out. Basically, here's how poor person's copyright works. You take your manuscript, you make a bunch of copies, you stick them in envelopes, seal them very well, so that they cannot be opened, by accident, and then you mail them to yourself. Why do you mail them to yourself? Because when they come back, they have a postmark on them. And that postmark proves that the manuscript was in existence on that date. Again, what you're trying to do here is prove the date of publication, the date that you displayed this work to the world for the first time. This is an old system. It still works. I sometimes do it with my book manuscripts still. I got a bunch of these in a box down in my basement. Now, and of course, when it arrives in the mail, do not open it. Keep it sealed, because the seal and the postmark together is what protects you in a poor person's copyright. Okay, so how do you register a copyright? So let's say that you do want to register the copyright. You must make a registration with the Copyright Office. That's part of the Library of Congress in Washington, you need to send them the correct application form, a non-returnable copy of the work. Do not send them your only manuscript because you will never get it back. Right now, the Copyright Office is not set up to take digital submissions. That they're working on it now, and it may be possible that by the time you listen to this program a year from now, it may be possible to do that. But right now, they're only taking them in paper or audio recording format. They cannot take them in digital form. There's a filing fee involved. It's between $40 to $80, depending on the type of work that you're filing. And you can file electronically, although the non-returnable copy of the work must still be submitted in paper or audio recording format. And that's the website URL for how you can figure out how to do that. Okay, who owns the copyright? The answer is the author or creator. Okay, that's at the moment the work is created, they're the only people that are out there. Okay, I'm looking at a couple of questions here. Okay. We have a couple of questions here. One question, and it's a very good one. I'm going to answer this right now. Some people commented on my copyright. You notice that there's a range of years here. And why is that done? I'm going to explain that in detail in a little bit. But whenever you create a work that is constantly being revised over time, it's a good idea to do the copyright this way, because each new revision that you do adds a year to the copyright protection. Is what it does. So I first gave this presentation in 2015, but every time I do it, I tweak it a little bit. I update it based on questions that I receive from attendees like you. So this is why I have it this way. By doing it this way, I add a year to the copyright protection. And when we get to that, I'll repeat that. But it's a good question, so I figured we would answer it now. What happens when you die? Well, the copyright does not go away. You can transfer your copyrights by will. It's a very good idea to do that in your will, and you make it a specific bequest. Do not put it in as part of your residual estate. You know, that's the miscellaneous category. Everything that I didn't specifically give to anybody in my will goes into the residual estate, and it gets split up between my 14 kids. That I know of. That is how a will is drafted. So you want to make sure that there's a specific bequest of your copyrights. A lot of authors put it into the copyrights into a trust, and the income from that trust gets used for various charitable purposes. A lot of authors like to do that. Even if you're a minor, you could be a successful author at the age of 12. There's nothing that said. The only problem with being a minor is you cannot legally enter into a contract until you're either 18 or 21 years old, depending on what state you live in. So your parents are going to have to sign contracts with your publisher or whatever. But you can be a best-selling author at the age of 12. I know a lot of computer code geniuses that haven't yet reached puberty as yet. It's amazing to me. They make more money than I do. There really is no justice in this world. You do know that, okay? But especially in this area. Now, here's a trick: if you create a work of art, a creative work, as part of your job, as part of a W-2 employment or relationship, you do not own the copyright to the work, even though you were the creator or the author. Your employer owns that. It's called the work made for hire doctrine. And we're going to talk about that later. Not the owner of a physical object. If you're an artist and you sell your painting at a gallery, you have not sold the copyright. The person that you sold the painting to can hang it on their wall. They can put it in their basement. They can destroy the bloody thing. There are copyrights to works that were destroyed by the Nazis during World War II that are still valid copyrights. The works themselves no longer exist, but the copyrights continue. That's why I say this. Remember that hologram. You can take the painting away, the hologram remains, but also not your client. If you are an independent contractor, if you create a work of art for somebody else as an independent contractor, you retain the copyright unless you specifically assign the copyright to them. We'll talk about that later on when I talk about the work made for work made for hire doctrine. I have a whole slide on that. What does copyright give you? It gives you the exclusive right to profit from and make copies of the work. So if you're an artist, you can sell the original painting at a gallery, but you still retain the right to make reproductions, seriographs, lithographs, all the things that they sell at the arts and crafts shows. You can still do that, which is why you should always have very good digital copies of the works. The exclusive right to profit not only from the work, but any derivative works that are based on that. So if you write a best-selling novel or screenplay and I turn it into a Broadway play, I write the Broadway script, that Broadway script is a derivative work of your novel, and you get royalties on the Broadway show as well as the screenplay or the novel that you wrote. The exclusive right to edit, alter, or change the work. The person that buys your painting at a gallery can destroy it or do whatever they want to it, but they can't put a mustache on it, or if it's the Mona Lisa or something like that. They cannot alter the work without your consent. But the most important right is what we call the infringement right, the right to sue others who infringe your copyright. That means ripping you off and then make them pay through the nose. That's really why you want to sweat your copyrights. Okay, profiting from copyright. How do you make money off a copyright? Well, you can either sell it or you can license it. Those are the two basic choices. Selling and assigning the copyright is the same thing. If you sell your copyright, you've given it away. You no longer own it. Now, if you write a best-selling novel, when you do your contract with the publisher is going to want you to assign the copyright to them, because they're the ones that are taking the risk of publishing the book and distributing it to the Barnes and Nobles and the Amazons and all the bookstores around the world. And they will record the copyright, but they will record it in your name as the creator. The way they normally do it is they will say, this is, best-selling novel by Cliff Ennico, which has been, the copyright is owned by Mr. Ennico, but it has been assigned to Simon & Schuster. That's how it's done. They get there as the assignee. You are the creator of the work. Whenever someone else is copywriting your work for you, make sure that you are always identified as the author, as the creator. The other thing that I like to do when I do a publishing agreement, especially since I deal with a lot of smaller niche publishers that go in and out of business, they get acquired by other companies. I always put a provision in there that if the work is no longer in print or sales fall below 100 per year, I get the right to claim my copyright back. All I have to do is send them a letter and my copyright comes back to me, and I record an assignment with the Copyright Office assigning it back to me. Licensing is the other way to go, and in many ways it's the better way to go. It's almost, think of it as a lease, and you're kind of close. Basically, you retain all rights. You don't give away your copyright, but you specifically grant somebody else the license or permission to do certain things that are usually very specific. You can do A, B, C, and D, but you can't do E, F, G, and H. That's how a license is typically put together. A license is not forever. A license is usually for a very specific period of time, and unless both parties decide to renew it, the relationship's a productive one, a profitable one, it expires at some point. Be very careful when posting your artwork on social media. A lot of people don't realize this, but if you read the terms of use or the user's agreement of social media sites like Facebook, Twitter, Instagram especially, be very careful, because those contracts which you are agreeing to by posting things on a social media site, you agree to their user's agreement. You are agreeing to those terms and conditions. Most of those users agreements contain an assignment of rights clause where you are assigning your copyright to the social media site. Now, they are doing it. They're not doing this for bad reasons. They're not trying to rip you off. What they want is, if they get into a situation where you post something online and it becomes a runaway hit, it's being viewed by millions of people around the world, and they want to, and Facebook wants to do like, here are the 10 hottest, postings of the last 24 hours on Instagram, and yours is one of them. They want to be able to do that without paying you anything. And that's why they're asking for the assignment of rights, is they want to be able to promote you and publish you and put you up there without having you come back and say, well, that's great, you got 1 million hits, I want $1 for each one of those. That's what they don't want. And that's why that clause is in there. But keep in mind that if your work is not very well protected, if you don't have it watermarked or somehow encrypted so it cannot be copied. I mean, I do it all the time. I can go on Instagram and I can cut and paste into my computer somebody else's photo or somebody else's artwork. I mean, I don't do it for business reasons or for any nefarious reasons, but it can easily be done. So be very careful. What I tell my clients to do normally is, by all means, promote your works on Instagram, Facebook, all the social media sites, but don't post the actual work up there. Post it on your website and put a link to your website on Instagram, Facebook, because that way, when somebody looks at the actual work, they're on your website. It's your rules, your terms and conditions, your privacy policy that govern, not Facebook's or any of the other social media sites. I know this surprises a lot of people. We always get a lot of questions about this. I'm going to put them off until the end, but be very careful. If you're going to put the actual work itself on a social media site, make sure it's encrypted, watermarked, protected in some way. Your web person can help you do that. Okay, we talked a little bit about works made for hire. Let's drill that down. If the work was created in the course of your employment, the employer, not you, owns the copyright in the work. But there's a very big difference here between employees and independent contractors. So if I create a work, if you hire me as your attorney and I create a work of art, a literary work, if I create a brief for you or something like that, I own the copyright to the brief. You can use it, of course, in your defense, in your lawsuit, whatever, but you cannot make copies of that brief and make money off of it. I will come after you, or my attorneys will come after you, who are a lot tougher than I am. Believe me, I work with some pretty tough people. I make sure they get paid on time too, by the way. Very important thing. An independent contractor must specifically assign their copyright to the client, or else they retain it. And we have a Supreme Court case on this. It's the Reed case. It was handed down by the Supreme Court in 1989. For those of you who are Supreme Court trivia buffs, it's the last opinion that Thurgood Marshall rendered before he retired from the bench in 1990. It was his last opinion. Reed was a sculptor. He created a bronze sculpture for an organization in Washington, which was designed to protect the homeless, basically. And it was a bronze sculpture of a homeless family that they were going to put in the lobby of their offices in Washington, D.C. So they commissioned the work. He did it. They went back and forth a little bit on the design. He produced it. He got paid for it. They paid him in full. They installed the work in the lobby of their building, but then it became very controversial. A lot of people didn't like the sculpture. They thought it was too avant-garde. They thought in some ways it kind of made fun of homeless people, which was not what this organization wanted. They went back to the sculptor and said, you know what? The sculptor's not really having the effect that we thought it would. Could you please just make these few changes to it, and we'll pay you for it? We understand this is additional work. We'll pay you for it. But the sculptor, Mr. Reed, said, no, that's my vision. That is the way I think it should look. You cannot change it. Do not change it. So they felt, well, geez, we paid for it, so we own the bloody thing. We can do whatever we want to it. They hired another sculptor to come in and make the changes. And Mr. Reed sued the organization for copyright infringement. It went all the way up to the Supreme Court, and Justice Marshall basically sided with Mr. Reed and said, yeah, he sold you the work, but he did not sign you over his copyright. If you want to make changes to a work of art, you must own the copyright or have a hard and fast assignment of that from the original creator. If you do not have that, you do not have the right to monkey with it in any way, shape, or form. You must put it back the way it was at your expense. So that's the case that has, that's why whenever you sign any kind of a contract with a client where you're doing creative work, you're creating any kind of written deliverable or an artistic deliverable, there will always be an assignment of rights language in there, because without that language, you still continue to own the copyright on what you do. Okay. Now, but a copyright is not forever. It only lasts for a certain period of years. After that, the work goes into public domain, and anyone can publish the work without any kind of monetary obligation to the creator or author. Now, let me make this very clear. Right now, a lot of the works of Mark Twain are going into the public domain. It's been, over 100 years since he died. I think it's about 110 years now since he died. So his copyrights are going into the public domain now. That does not give me the right to publish The Adventures of Huckleberry Finn by Cliff Ennico. That does not give me the right to steal that. Even though the copyright has expired, the Twain estate can still sue me if I infringe. Okay. But what I can do is I can publish The Adventures of Huckleberry Finn by Mark Twain in my own private edition. And I don't owe anything to the Twain estate for that because it's in the public domain. Again, a copyright has nothing to do with who owns the work. It has to do with the right to make copies, the right to publish. I can now publish works of Mark Twain. And for music, the publication is a lot shorter. That's why you're seeing now a lot of compilations of music from the 60s and 70s, because what's happening now is those copyrights are going into public domain, and somebody other than the original publisher can get a hold of the masters and reproduce a lot of, the Beatles, the Rolling Stones, and all that stuff that they did back in the 60s. Here are the dates. I won't belabor these. For works created after January 1, 1978, copyright protection lasts for the life of the author plus an additional 70 years. That's a long time. That means if something happens to me at the end of this program, if I get a massive heart attack and die later today, my estate will still own the copyright until 2091 on all my literary works, including this program. That's a long time. For an anonymous work or a pseudonymous work that was created under a pseudonym or a work made for hire, the copyright is longer. It's either 95 years from the year of its first publication or a term of 120 years from the year of its creation. For works published prior to January of 1978, that's the last time that the federal copyright laws were updated, you have to look at the copyright law that was in effect when the work was first published. And I've given you here 3 very good websites. You want to bookmark these. Basically, you can type in the name of, especially for literary works, it's very good for this. You can type in the name of the work, and it will tell you exactly what the copyright law was and what the term was on the date that the work was created. So that's it. Okay. Watch out for translations and subsequent editions, though, because a copyright can be revived. If I create a literary work and I do a revision, a second edition of that work, the copyright attaches to the second edition. In other words, and that triggers another period of 70 years. That's why if you ever went to college, and especially if you took any science courses, math and science courses, the textbooks were always being updated and revised every year. You got the 42nd edition, which maybe had 2 paragraphs more of information than the 41st edition was. And that's why the textbook publishers did that. They always update their books every year because that adds another year to the copyright period. That's why, to answer the question one of you asked earlier, that's why I have the 2015-2121 at the bottom of each of these slides, because every time I revise it, I want that 70 years to go 1 year further into the future. Okay. Oops, hang on a second. Let's do this. Okay. What about subsequent editions? They can be separately copyrighted, but not if there were only editorial changes. If all you did was correct a few typos, that's not a new edition. Yes, though, if you added a new chapter to the work. So if you have a work, let's say it's a work you're publishing online, and you want to keep adding a year to the copyright term, what you need to do is you need to change at least something each year and create some new content, even though it's only a paragraph. That allows you to call it a second edition. And textbook publishers, like I say, are the worst offenders here. That each year they only add a couple of paragraphs to an 800-page textbook, but they can justify calling it a new edition because they do that. Okay, let's talk about derivative works. We talked about this earlier. Copyright protection, if you have a copyrighted work, it doesn't just extend to the work itself, but works that are based on that work, which are called derivative works. So to use my previous example, the author of a Broadway play that's made into a movie has a copyright on the screenplay, unless, of course, they assign it to the movie producer, which they're almost certainly going to be required to do. But not everything is a derivative work. The law protects parodies of copyrighted works, which can be copyrighted in their own right. I love talking about these 2 cases. These were 2 cases from the early 2000s that were decided by the Second Circuit. That's the Federal Appeals Court in New York City, one of the most liberal progressive courts in the country, which is important to know. Back in the 1990s, a lady wrote a book based on Gone with the Wind by Margaret Mitchell, the Civil War epic, famous movie from the 1940s. But she wrote it from the perspective of an African-American slave on the Tara plantation. And she called it The Wind Done Gone, is what it was called. It was basically the basic outline of the Gone with the Wind story, but it was told from the perspective of a slave on the plantation, not the one that was played by Butterfly McQueen. This was a slave that did not appear the narrator of that book was not a slave that appeared in the original book in any manner, shape, or form, which was a key fact in this case. Well, the estate of Margaret Mitchell was not too happy about this, so they brought a suit to enjoin the publication, basically prohibit publication of this book or get royalties on it because they felt it was a ripoff of Gone with the Wind. And it went all the way to the Second Circuit, and the judges there said, you know what, it isn't. And it's not a derivative work because all of the text of the book was original. Now, some of the characters like Rhett Butler and Scarlett O'Hara do appear in the book, but none of the dialogue. The author was very careful not to use any of the same dialogue or repeat anything that was in the original book. All of the text was original, and it was from a different viewpoint of someone who was not a character in the original book. So they said this is not a derivative work. What they said is the work is transformative. The author of The Wind Done Gone changed enough of Gone with the Wind that the work can stand on its own 2 feet and it can be copyrighted in its own name. Okay. Now, about 3 months later, okay, the Second Circuit looked at a second case, and this one was different. In this case, an author in Sweden. Do you remember the book Catcher in the Rye by was it J.D. Salinger? We all had to read this book. Those of us who went to high school in New York, when you got to your senior year English class, there were 2 books you had to read. You had to read Catcher in the Rye, and Death of a Salesman by Arthur Miller. Those are the 2 things you had to read in senior year English. I don't know about you. I hated Catcher in the Rye. I detested that book, and I do to this day. Holden Caulfield is one of the biggest snots that has ever been written about any literary character in the world. I mean, there is nothing sympathetic about Holden Caulfield. I never liked that book. I mean, it's the coming of age book, you know. I've never bought into it. I've never gotten into Catcher in the Rye, and I never have. But an author in Sweden didn't feel that way. He thought it would be really cool. He was a big fan of Catcher in the Rye, and he thought it would be really cool to write a book about what's Holden Caulfield up to today. You know, he's in his 60s now. He's a baby boom geezer, you know, who's getting up there in years. What is his life like now? What would his life be if, you know, in his 60s or early 70s? So he wrote a book. I don't remember the title of it, but it's basically Holden Caulfield as a baby boom geezer. And he used, of course, the Holden Caulfield character. The character refers back to several things that happened in the original Catcher in the Rye book. He uses some of his trademark phrases. So, for example, in the original book, he talks about people being phony. Well, the 60-year-old Holden Caulfield does exactly the same thing. The estate of J.D. Salinger did not like this at all. They thought that this was an infringing work. It went all the way up to the Second Circuit. And the Second Circuit, now 3 months after they decided the Wind Done Gone case, they went completely the other way. They sided with J.D. Salinger's estate because the Swedish author used the same character name. A lot of scenes from the original book, a lot of the same dialogue in the book was repeated. Holden Caulfield remembers 50 years ago, he said this, that, and the other thing. You know, there was enough of the original text that was huge that this was a derivative work. And J.D. Salinger's estate was not looking for money here. They were not looking for royalties. They were looking to shut the book down. They wanted to enjoin publication, basically prohibit the publication of this book in the United States and Canada. And the Second Circuit agreed with that. The Second Circuit, one of the most liberal, progressive courts in the country, enjoined publication of this book and said you can't publish it, you cannot sell it anywhere in the United States. If you have a copy of it, in English, it is probably a collector's item that you might be able to get some money for, some decent money on eBay for, or something like that, because its book was banned by one of the most liberal courts in the country. So that's how you avoid becoming a derivative work. If you look at those 2 cases and you look at them side by side, you have what you need to know to create a work that is transformative. That's the word that the law uses to say that a work is sufficiently different from the work that it's based on, that it can stand on its own going to feel. What about things like fan fiction and mashups? You see these things all the time, especially in the Star Trek universe. There's a lot of books out there about, Kirk and Spock, and they got a thing going that's beyond, beyond their professional relationship. There's a lot of books like that out there. There are rules, okay? And if you got to be very careful whenever you do fan fictions and mashups. You have to be careful to make sure that the works are distinct enough from the original books that they can stand alone as transformative works and not derivative works. Otherwise, the owner of the copyright to all the Star Trek stuff will be coming after you either for royalties or to shut you down like they did the Swedish Holden Caulfield book. Bottom line, owners of highly popular works have lots more money than you do, so don't tick them off. They have the money to sue you. You do not have the money to defend yourself. So don't get anybody angry like this. Some of the better authors, like J.K. Rowling does this beautifully. If you go to her website at jkrowling.com, she actually has a section of her website where she tells people exactly what they can and cannot do when they create fan fiction based on the Harry Potter books. She tells them the do's and don'ts. So for example, Harry Potter and Ron Weasley will never cheat on their spouses. That will never be part of a fan fiction plot because that violates the integrity of those two characters. If you read her site, and the better authors will do this. The more popular authors will create rules to help their fan fiction authors, because let's face it, it helps them when an author does a fan fiction. Okay, we're going to talk a few minutes about fair use, and that's the end of the program. So up till now, we've been talking about you as the author of the work. Okay. Now, what happens though if you're not the author? Let's say you want to use somebody else's copyright works. Can you do that? The short answer is no. The law is really very clear. If someone else has a copyrighted work, you cannot use their work. If you are the author, somebody else cannot use your work unless you give them permission or unless you get permission. I get requests for permission all the time for my articles. I have a weekly column that I write for Creator Syndicate in Los Angeles called succeedinginyourbusiness.com. And every week I get an email from a professor somewhere who wants to reprint my article in a specialized course handbook for his students. I always say yes. I never charge money for that. I'm happy to let them use it, and even though they're making a little bit of money off it, it's introducing my work to a new generation of readers. That's why I like it. That's why there's the law and then there's reality. As long as somebody is using the work for a valid purpose that helps me rather than hurts me, most authors, I think, will let other people use their works, as long as they're not being too greedy about it. But the basic rule is, though, you cannot use somebody else's copyrighted work unless they grant you specific permission. Now, what about all those college term papers that you wrote where you had all these footnotes where you basically reprinted the whole book in the footnotes to your college term paper? Okay, there is something called the fair use doctrine. And what it says is, as long as you give the author credit, as long as you don't claim that you are the author of the work. So for example, I can't say that The Adventures of Huckleberry Finn by Cliff Ennico. I cannot claim authorship of that book. That will always belong to Mark Twain or his estate. As long as you give the original author credit, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. That's why no one ever asked you for royalties on your college English term papers. That's what got us all through college. But there are no legal rules permitting the use. A lot of people think of this. There's no legal rule permitting the use of a specific number of words, a certain number of musical notes, or a percentage of a work. Fair use depends on all the facts and circumstances. Some of you, if you're a baby boomer, you recall that back in the 70s, George Harrison, one of the Beatles, wrote a song called My Sweet Lord, which used a lot of the same basic theme as a doo-wop song called He's So Fine by the Chiffons in the 1950s. And it went to court. It actually went to the highest court in England, and the court sided with the Chiffons, basically. George Harrison's estate now has to pay money to the owner of the rights to He's So Fine each time the song My Sweet Lord plays. And again, that was based on just a few notes that were the same in both works. there is no rule. A lot of people think that there's a rule. Well, as long as it's less than 50 words that I'm copying, I'm okay. That does not exist anywhere in the law that I have seen after 40 years of practicing law. I have never seen that. It does not exist. So how do you find the copyright owner? What do? Well, there's a number of places you can do. Look, the Copyright Office will help you for a fee. If you are a summer intern at the Copyright Office, this is what you spend a lot of your time doing, is chasing down what they call copyright searches, where somebody is looking to find out who does own the copyright to this 3-minute song that was done in 1952. You're going to spend a lot of your time doing that. The Copyright Office circulars, by the way, are wonderful. They're in plain English. It's one of the best things the U.S. government publishes. If you're looking to do something in the Copyright Office, find out if there's a circular on it and download it. These are all free downloads. Your tax dollars pay for this. Take advantage of that. And they're all in plain English. And they're very easy to follow. There are places called collective licensing agencies. So ASCAP and BMI are the most commonly known of these in the music world. I gave you a website where you can find these people. There are permissions editors. These are usually retired book publishing editors who, to keep their brain cells active instead of doing Sudoku puzzles, they're basically helping people find out who the copyright owners are for various works. I gave you a site where you can find these things, these people. When all else fails, hire a copyright lawyer who knows what they're doing. Okay. What about other types of people? So for example, let's say you find a photo and you really want to reproduce this photo in your creative work because it's perfect for what you do. Well, you obviously have to get a permission of the photographer. But what about the people in the photo? Do you have to get their permission to reproduce the photo? And the short answer is you may have to. Everyone has what they call a right of publicity in their license, likeness, voice, or image, and a right of privacy. So let's say, for example, you take a photo of a crowd scene, and there I am. I'm in front of this crowd. I'm leaning against a lamppost, and I'm picking my nose, or something disgusting. Okay, believe it or not, you do not have the right, even though the background image may be something that you can copyright, because let's face it, you can't get consents from 50,000 people in a mob, but you may have to edit me out. If I can be individually recognized in there, you may have to Photoshop me out of that. Otherwise, I do have the right to that, and you can't really reproduce that image without my permission. I apologize. I left this in here. I mean, if this were a live presentation, I would have told you at the beginning to please don't say anything during the presentation, because I do want to put this up on my YouTube channel, and I don't want your cough to have to be made, be publicized worldwide. If the subject of a work is a recognizable person and you want to make money off the work, you must get the person's permission. Some of you know there's an indie rock group, an alternative rock group called Vampire Weekend. A number of years ago, they came out with an album. I don't remember what the title of it was, but the cover was a photo of an 18-year-old girl who was like a deer in the headlights. Somebody, they flashed the photo, and she was going like this. Okay, it wasn't anything dirty or anything like that. Here's what happened. Apparently, they found this photo. Don't ask me where they found it. Of this, I guess this, a number of years ago, there was a party at somebody's house, high school kids, and this one girl, who was very popular, whatever, she was in the bathroom, and they all decided it would be really fun to treat her like a Hollywood star. So when she came out of the bathroom, all these flash bulbs went off at once. So she came out of the bathroom, they took this photo. That's why she's looking like this, because she's startled, right? Well, apparently that girl went on to become a famous international fashion model. And when Vampire Weekend came out with the album with that photo, she recognized that photo, she lawyered up, and she sued them for millions of dollars, which I understand she won. Or they settled it. I don't know exactly what happened, but she gets a few pennies of royalties now. And if you're a Vampire Weekend fan, you know the album I'm talking about because of the jacket art that was used. Okay, can you take a photograph of a monument or a building and use it commercially without permission? Can you take a picture of the Empire State Building? Okay, the answer is yes if the building is public and you shoot from public property. These are the rules, by the way, and they change constantly. To my knowledge, there is no copyright on the Empire State Building, but there is a copyright on some other buildings too. You have to look into this. You have to look into whether the building is copyrighted or whether and where you are standing also has to be public property. Both of those things have to be public property. Be very careful about photographs. The Getty Images people in California own the copyrights to virtually every historic photograph that has ever appeared in a newspaper or magazine during the 20th century. So, for example, the photo of the sailor and the nurse kissing in Times Square at the end of World War II, we all know that one. That is copyrighted by Getty's Images, and they are ruthless. Ruth, I'm sorry, but they are ruthless about enforcing their photographers' copyrights. They see themselves as being in a fiduciary relationship with their photographers. If you take a photo that they own a copyright to and you put it up on your website, they will come after you and they will want $10 for each day that that photo was on your website without permission, and they do not back off. I have negotiated with them. They will allow you to pay over time, but they will never write off or write down an amount. They will come after you. They will lawyer up. They will find a lawyer in Connecticut and they will go after you if they see that you have used one of their photographs. So if you're going to copy photographs on your website, be sure you check the Getty Images database and make sure that that's not one of their photos. And if you're not sure, have a lawyer do this for you, because you do not want to make a mistake there. The Getty Images people are ruthless. So that's sort of the end of our prepared remarks. You do not have to register the copyright to have one, but you do need to have some kind of proof of publication in case somebody comes out of the woods and says, hey, I really own the rights to this. This is mine. You ripped me off. Watch out when creating works that are based on other people's intellectual property. Make sure that you do have fair use, and always err on the side of getting permission when other people or places get into works that you plan to exploit commercially. So that's basically it. Here are some suggestions. The U.S. Copyright Office has some wonderful circulars, and this is where you can find them. They're all free. They're all you can read them very easily. They're in plain English. Anything to do with the registration process. So for example, some of you are photographers, you probably know you can now do a bulk registration of your copyrights. Instead of copyrighting each photograph individually, you can photograph up to, I think it's 100 photographs at a time for one fee, but there's a very specific way you have to do that. The Copyright Office has a circular that tells you with screenshots exactly how you have to do this. And it's the best thing out there. And it's totally free. There are some good books out there. The Copyright Handbook by Stephen Fishman is kind of a classic. It's published by Nolo Press, and for fair use, the Nolo Press people used to do a beautiful book on fair use, but unfortunately it's out of print now. The best one that I found online on Amazon was this one by Lee Wilson called Fair Use, Free Use, and Use by Permission, which covers all the basic rules. This is who I am. And of course, I don't have a copyright on this. You can use my photo. No, that's not true. My photographer owns the copyright to this. I never asked her for a copyright assignment. That's how good I am. Okay, now we do have a couple of questions. And before I pass the floor over to Ruth, I know somebody asked a question before when we were talking about independent contractors. What if you are in the business of creating design work for other people? Let's say you are a graphic designer or a website designer and you're constantly creating works for your customers. Well, if your customer has a lawyer, they are going to want you to assign the copyright to the actual finished product, the deliverable, over to them. But there is language that you can put in the contract, which a good attorney will know, that says basically the client owns the copyright to the actual finished work, but they do not have the right to any of the forms, templates, tools that I used to create that deliverable. I can use those tools for other clients and you can't do a thing about it. What I cannot do, though, is give them the right to the exact same work that I created for you. And that should be okay, because when you create a work for a client, that work usually contains stuff that the client has contributed and that they own the copyright to. You couldn't use that same stuff with somebody else anyway. I don't want my face being on somebody else's website without my permission. That's not going to happen. Okay. So what you want to make sure is when you do your contract, make sure that that clause is very well drafted. So for example, I use form contracts all the time with my clients. Now, I will not take a contract for another client, fill in the blanks and hand it to somebody else as a finished work of art. I will not do that. Every client is a little bit different, but I want to make sure that a client cannot prevent me from using that form document for another client if I think it's a good fit for what the client is trying to do. So a long-winded answer, but that's the answer that.
That's great.
Ruth, what else do we have?
Well, there are quite a few more questions. But quickly Can you look at them with me? One
Yeah,
of them
let's
here
do that.
is a method book copyrightable? I'm
Like
not
a how-to book. Well, I certainly hope so, because I've written about 16 of those.
okay.
So I answer is I really hope that they are. The answer is yes, but you have to be careful. So for example, I wrote a book a number of years ago on the legal issues involved when you sell on eBay. Now, of course, I have to use the word eBay in the book title. I mean, you can't write a book about eBay without using eBay in the title. eBay is very fussy about that. You can use the letters EBAY, but what you cannot do is you cannot reproduce eBay's logo, which is the word eBay, but with primary colors and in a certain font. That they will not let you do. So for example, when you look at my cover of my eBay book, it doesn't have the eBay logo with the, the primary color fonts. It just has it in all black letters. And eBay is okay with that. They do not see that as infringing their trademark. So that's the one thing you have to be careful about when you are using logos or other trademarks of someone, like how to do something on Amazon. You got to make sure the name Amazon appears in a way that the Amazon people will not view it as trademark infringement. But usually they will let you. Because here's the thing, there's copyright and there's the real world. And I'm going to illustrate this. I think I can do this in the minute that we have left. A number of years ago, I wrote a book on, it's called The Legal Job Interview. It's a guide for young lawyers on how to interview for a legal job. And this was back in the early days of the internet, the early 1990s. Well, some law student somewhere out in the Midwest got a brilliant idea. He put together a website called The 100 Best Books for Young Lawyers and Young Law Students. And my book was ranked #1 of those 100 books. Now, what he did on his site, he listed each book, he downloaded a copy of the cover from someplace, and he actually included about 3 or 4 pages of text from each one of the 100 books that he felt was the best. Now, technically, that is copyright infringement. He infringed my copyright. But let me ask you, am I going to do anything about that? Hell no, this guy is helping me out. He is giving me publicity. He is saying that I am the author of the best book that has ever been written for young law students. I want to help this person. I want to give him more of my content because he's doing me a great favor. Now, let's say, though, let me change the facts a little bit. Let's say that this website had been called The 100 Worst Books for Young Lawyers, and my book was #1. How would I feel about that, do you think? Answer, I would have lawyered up and shut this son of a gun down. Okay. I love to tell that story because there's copyright, but there's the real world. If you really are walking a fine line on infringing somebody else's copyright, make sure that you present that person, that thing, in the most positive light possible, so that if they do find out about it, they'll say to themselves, well, you know what, this person is really helping me out. They're giving me some free PR here. I'm not going to go after this. I'll keep my eye on it, but right now I don't think this is a problem. I'm not going to try to shut this person down. Let's see where this goes. That's what you want them to do. So that's just some common sense stuff.
Cliff, could you take a quick look at the questions that are on chat and Q&A? I think you covered a lot of them after they were put up there.
A little bit, that's right. Is it adequate to have the copyright statement in a photograph's metadata? The answer is yes, as long as it's easily accessible. And I would say the technical, legally correct answer is yes, but I don't like it. I like it to be visible to people. I want people to know that it's a copyrighted work. And unless you're technically sophisticated, you don't know how to access the metadata on a site. So I would not do it that way. I would have it as part of the image, usually in the at the bottom or in a corner somewhere, where it can be easily seen. Without my glasses. How long does it take to get the copyright approved through the Copyright Office? I mean, if you're filing electronically, you'll get a preliminary approval right away, subject to your submission of the non-returnable copy of the work, which may take time. If you self-publish a book on Amazon, who owns the copyright? Yeah, there's a section of Amazon where you can self-publish books. You really have to look at the user's agreement because they are acting as your publisher there, and they do own your copyright for certain purposes. Make sure you look at the it's called Create Space. Amazon Create Space is where you can actually self-publish books on Amazon. make sure you look at the fine print, because they have rights and they are making a ton of money off of you by doing that. Does one copyright with their pen name, real name, or both? You can use a pseudonym. And in fact, if your pseudonym becomes, extremely popular, you can even trademark it. If you do, and writing under a pseudonym gives you a longer copyright period, as I discussed, but it also means that people don't know who you are, which can have a downside, later on. What is the copyright date on a photograph? Date it was taken, or the date? Well, the copyright attaches the date that it was taken, but you also have to prove the first publication of the work. So the date that you posted it on your website would be the date of first publication. I mean, you can take a photo and keep it in your camera for years. I mean, eBay people do this. They scour estate sales. They find cameras with photos that are still in them from 50, 60 years ago. The date it was taken doesn't really matter at that point. It's the date of first publication, I think, that's going to govern there. Talk to a good copywriter about that. For getting ideas from sites such as Pinterest and making artistic works, combining references, would that be applicable under the fair use doctrine? The answer is yes. If you're taking someone else's original work, even if it's only a few lines of text or a photo, and you're incorporating it into another work, you are in fair use land, and you have to know what you're doing there. I've seen photographs at MoMA that were appropriated. For example, a woman who existed photos taken of Jackie O by Ron Galella. How could that happen? Well, the short answer is let's face it, MoMA has very good lawyers. So they definitely knew what they were doing there, and they probably had the legal right in some way from those, maybe from Ron Galella's estate. The short answer is, I don't know. But if they're in MoMA, MoMA does not go around stealing other people's stuff. So they have good lawyers. Would you advise copywriting a company name? No, the answer is no. You do not copyright company names. You trademark them. We're going to be talking about trademark next week. So wait till next week. Please come back and we'll answer those questions.
Yes,
and I think I'm done here.
Well, thank you. I think you covered a complicated subject very well. And if anybody absolutely feels that something has been left out that they asked about, can they drop you a note?
Yeah, they surely can. Send me an email. Once the call is over, the chat room disappears. So send me an email. You have my email address right there in front of you. Don't forget the R. It's crenico@gmail. If you go to crenico@gmail, it's my cousin Christopher out in New Jersey, and he'll charge you. So make sure you put the R. But thank you. It's always a pleasure to be of service to SCORE.
Well, this is just a reminder that there will be a recording of this webinar on the website for fairfieldcounty.score.org. And we also want to remind you that we do value the evaluation that we're going to be sending if we get a reply from you. So please just take a minute and fill it out and let us know how you like this and what other things you feel SCORE might be able to offer in the way of subject matter. So on behalf of SCORE, thank you all for coming today. And especially, we'll see Cliff back on August 3rd, a week from today, for the Trademarks seminar. So in closing, a big thanks to Cliff and all. Stay safe. Thank you,
Ruth. It's always a pleasure. And it's August 10th. Next Tuesday, we'll be talking about trademarks. Thanks.
Is it? Yes, you're right. August 10th.